Hey guys, it's your legal bestie, attorney Symone. Let me know, put a thumbs up if you can hear me in the chat. I'm using a new microphone here. Let me know if you can hear me in the chat. Apologies for the delay. You can see the natural light here. It is morning time and I have been working all night. Hey guys. Yep. Let me just make sure you can hear me. I have been working all night. Okay, great. All right, I will continue. All right, so the verdict is in. The verdict in the Karmelo Anthony case, and that's what we're going to talk about here. I actually have you guys on my TV screen. Oh yes, as you guys are putting your questions in the chat, I am starring them so I can ensure that I make sure that I address them. I see Daisy's got a question about sentencing. Indigo wants to know about the all-Caucasian jury. The verdict is in. Yes. So the verdict is in. Where I'm at this morning, I am actually in Bali, Indonesia. I'm in Indonesia. That's why I look so happy. And let me tell you, the more I hear about cases and situations like this one, the more I'm not in a hurry to get back. I am in a hurry to get back, but I want to get back safely. I want to get back in one piece, etc. So because of my house here, the way my house here is situated, my guest room has better Wi-Fi. So that's why you're getting this backdrop today. I wanted to make sure I don't get all super blurry on you. Someone says it was not an all-white jury. I am going to star that too. We're going to talk about that not all-white jury. Thank you. The lies are just lies told by Karmelo's liars. Okay. Looks like Rex Goodheart is upset, boy. Rex is upset. Okay, Rex. Hit that like and hit that subscribe as you come into the chat. Listen, so first off, I wanted to be clear. Yes, the verdict is in. So the verdict is in. The verdict is guilty of murder one. We're going to call it M1 for YouTube purposes. Hold on. Let me get it. I'm typing it on here. All right. And I wanted to be clear. I wanted to make sure that I clarify that it is guilty of the M1 because as I predicted yesterday, and apologies if you're seeing my videos different than when I post them because I am 13 hours ahead. But there we go. That is misspelled, huh? But I predicted yesterday, I said that there was a chance that manslaughter could also be on the table. Hold on, let me adjust that. There's a typo, obviously, there. Verdict is in. My vision is bad. There we are. All right. So the verdict is in. There were basically the main charge this entire trial has been M1, which is premeditation. There's two things that needed to be proven there. And I wanted to clarify because in Texas, premeditation isn't what most people would think of it. It's not, oh, you had to have planned it and gone in there with a specific plan that like, oh, I'm going to unalive this person. No, that's not how M1 works here in Texas. Instead, how it works is it's two different things. It's either intentionally, like you did it with the intention to take this person's life, or knowingly. You did it knowing that there is the substantial likelihood that what you're doing, stabbing someone in the area of a heart, is going to likely create death. I'm going to pull up the exact wording of that because this is really, really important. Hold on. For the intentional and the knowing, I want to make sure you understand so that you know the difference between that and versus manslaughter. Hold on. I had it here. Oh yeah, we have this one. Okay, yes, that he had to have the prosecution had to prove, of course, Austin passed away as a result of Anthony's conduct, but more specifically, he either intentionally did it or knowingly. But knowingly, that just means he was aware that his conduct was reasonably certain just reasonably certain to cause death. Now, I mentioned in the prior video where I break down Texas law that for the defense could argue this was a panic response, that what he was doing was a panic response, particularly here. Some of the facts that supported that were that it was just one stab. It was one stab. It wasn't like he did it repeatedly. It was stab and go. He stabbed him and he ran. But apparently the jury said, we don't care. The jury said murder won. Now, also, I want to let you know, manslaughter was on the table. And the difference there, is that manslaughter can come into play where the theory there is that he intentionally stabbed him in a vital area, but he did not know, but it was in the heat of the moment. He didn't do it with the intention of killing him. He used the knife, but it was in the heat of the moment. That he did it recklessly, and he recklessly disregarded the risk that it could unalive Hunter. Now, I'm sorry, Austin. What was interesting to me, and help me out here in the facts. Ooh, thanks. I got a super chat I see here. What was interesting to me is that manslaughter was never on the table from the beginning. Now, I'm going to tell you, some will disagree. I never thought there was a strong self-defense case here. The reason being is because when you're looking at these cases, you have to look at it from the perspective of the jury. And guess what? Every single one of those people on the jurors are. They're either parents or aunts or uncles of teenagers. And when they make a ruling and a verdict, you don't think of it as a juror. You don't think of it as a bubble of, oh, it just impacts this case. You're like, hold on. If I say that it is self-defense for a teenager to pull out a knife when he's in a fight with another student, then that means, hypothetically, if my child or my niece or nephew are ever in a schoolyard fight and someone else and let's say they're just punching each other and the other child pulls out a knife, that they could get off. I think the average parent that's on a jury would have a lot of difficulty finding that self-defense. And I understand there are certain, additional facts that are come into play here. But specifically, I felt that the self-defense was a difficult argument here, given that he wasn't being pummeled. Karmelo wasn't being, I've seen some people give commentary that said he was being jumped. There wasn't any evidence of that. If that happened, there wasn't any evidence of that in the trial. The evidence was that there was one shove. I had heard some description of it as a punch. In court, none of the students that testified described it as a punch. They said that Austin shoved him, pushed him, any of those words. But I always say, like, if you're going to pull out a knife, if you're going to pull out a weapon, you got to take a punch first. You got to take a punch. You have to be able to show or articulate that you felt your body you were in fear of serious bodily harm that could have killed you. And someone shoving you, even someone punching you in the face a few times, it's going to be difficult for a parent. Remember, jurors are parents. And this is a bunch of kids cutting up, thinking, oh, wow, if my kid were in a fight and someone else pulled out a knife on my kid and they stabbed him, should they be able to get away with it? Now, let's go down. I want to make sure you guys understand and are clear. Someone said, I did track and field. I don't ever remember someone bringing a knife to the meet. I wonder about that. We're going to talk about the jury. We're going to talk about the jury composition. We're going to talk about this sentencing range. And we're also going to talk about what do y'all feel were some of the weaknesses. I want to make sure, that we talk about Karmelo's legal representation. I think I saw a lot of people that were like, his attorneys failed and they set him up, etc., etc. I want to talk about it, and I think you might be surprised with my thoughts on that. We're also going to talk about the judge that this case is before, Judge Roach. I have been before him. I think he's a terrible judge. I don't really like him as a person. From what I know about him, I think he's shady. Now, under the law, I have to be careful as an attorney what I say about a judge, because you shouldn't say anything that could like frown upon judges, but you can say, this is a trifling ass man. He is a trifling ass. person. I'm going to give you my take on why I personally feel that about the judge. And then we're also going to talk about what are some of the limitations as far as what a judge can do under these facts and in these types of cases. I'm looking at the let me get these comments on the screen. I need y'all to see these comments. They're about to do the sentence. All right, let me go live. Hold on, I'm gonna do a screen share. Okay. Hold on. All right. Fucking hate Fox, but they've got live coverage. Hold on. Hold on. I'm going to do this. Oh, if y'all have a preferred live, okay, here we are. Okay. I'm gonna wait for. Okay, it says Karmelo Anthony live coverage. I'm waiting for an actual live, so I have it over to the side so that. Here we go. We've got a crowd that's gathered. That was 4 hours ago. I have a live feed over to the left. If y'all have a preferred live feed, let me know which one y'all like to look at. Because I want to make sure. Why couldn't they accept him standing his ground? All right, let me start that one. Okay. Yes, they are in the middle. They are in the middle of sentencing. Now at home, okay, let me see what time is it. 7 a.m. Okay, so it's 6:42. Yeah, they could still be they're probably still deliberating. Here's what's interesting. So they're in the middle of deliberating on the sentence now. Now the judge told them basically bring an overnight bag. When a judge says bring an overnight bag, a lot of times in the mind of jurors, they're like, we're sick of this. We don't want to go home. They will quickly, thank you. That's what I have Fox Live. That is I have on this other channel. Thank you. It's live now. Let me refresh. Live updates. Crowd awaits sentencing. Hold up. All right. So I have this is all right. Got it. Hold on. I'm going to share this. Share. Hold on.
The city council that range from $530 million to
Okay, I've muted this. This is just to show you. This is the Fox local coverage. And I'll just share this on the screen with you. It's not pertaining to the Karmelo trial. He better get life. Death would be better, but unfortunately they won't. I'm looking at these comments. All right, I'll shift this to the side while we're waiting. I don't think that they're going to come back with the sentence tonight because right now in Texas where they are deliberating, it is 6:44. More than likely they're going to let the jury. So the jury does have to stay in a hotel tonight and they're going to have to stay in a hotel each night until they determine what the verdict is going to be. So I have this in the corner in case they cut to something that's going to, I agree. I asked Symone if it has mods. We do have mods, but I started a little late. Hold on a second. Someone please deal with the vile comments. There's a clear difference. Gotcha. So what I'll do is I'm going to take them off the screen since We do have mods, but I want to let you know I started like an hour early, so my mods did not even know. Um, they weren't able to like. They probably had lives and stuff to do. Hold on. Interesting. Let me say something about these little vile comments and so forth that are over here. Is that everyone keeps saying, like, I see a lot of Caucasian people that are saying this isn't about race, this isn't about race. But if you look at your commentary, it's totally about race. If you look at the things that people are actually saying, it seems that they're very angry. You're angry with white people. Yeah, they're very angry. Somebody said it was bad before. Would the people in the comment section calling for a life sentence still feel that way if it was a BOB crime, as in black on black crime? I'm not sure. I'm looking at someone stabbing themselves. It was bad before. All right, let me put these comments aside because I'm getting distracted. That's why my ADD is messed up. Hold on one second as well, which is, oh shit. Hold on. Give me a second. I'm gonna hit refresh. So you may lose me for a quick second. I'm gonna hit refresh. All right. Hopefully this helps the signal. All right, hopefully this helps the signal. We are loading back up. Let me make sure the audio. Yep. Okay, you still got the audio. My apologies. And don't worry, I have not forgotten this super chat. The signal, I'm in Bali, Indonesia, so my apologies. I gotta wait. Y'all, I gotta get Starlink, which is its own thing. I don't want to give that man none of my money, but I don't have a choice. All right, so we are waiting. It looks like they're not gonna have a verdict in a sentence in today. They have the verdict in, but it looks like the sentence. We're gonna just make this as a smaller screen over to the side. There we go. So that if they do come in with that, I'll be able to see it, but I'm not going to deal with that right now. Someone said, he's cooked, donate more money. I don't know where my mods are, Harlem. You want to be one? Let's see if I can make you a mod. But thank you for asking. Hold on. Let me do that from my phone. All right, we're just going to do default audio from my computer. There we go. Audio's back on. Okay, we've got the audio part back on. All right, I don't think that they're going to, like I said, I don't think they're going to come up with a sentence tonight. And I do see this super chat. Let me start there. I really appreciate that. It is. All right. Oh, these are some good questions, y'all. All right, let's start. We're going to start with at the top with a super chat, which are super chats are questions that you guys can put that goes to the forefront. Sorry about that. Quentin said, ma'am, we've been waiting. I know you have. I'm so sorry. I'm 13 hours ahead and I have been working overnight on this project that I have coming out for you. But thank you so much for the support and your patience. We've also got in the super chat, of course, we've got where Allison said, where are the moderators? Allison, can I make you one? I'm about to see if I can. Allison Lewis, I'm definitely going to try to make you one as I multitask. And here as well, Amy J said, where were the adults in the tent? Why were teens left to manage other teens, and adults escorting Karmelo out of the tent could have prevented this? No, you're absolutely right. That's a legitimate question. And so some have asked, could Austin is the victim, could Austin's family sue the school? Could they sue Karmelo's family? The answer is they cannot sue the school. So in Texas, schools have immunity for damn near everything except for spanking your child or accidents that occur like on the school bus or involving transportation. And that's because car accidents are car accidents, right? I even had a client, excuse me, who unfortunately his child drowned on a field trip where the school failed to provide supervision, lifeguards, etc. on a field trip. And the school district had immunity. You can't sue. So the answer is that, like, even if there was negligent supervision by the coaching staff to allow this to happen, no, his family cannot recover anywhere with that. But I think that's a legitimate question. So I want to just make sure you're clear, though, on here's how sentencing works in Texas. Number one, it is the jury. It is not the judge. And I heard commentary this morning where someone was saying, whoa, that jury came back super fast. You don't want that type of jury to sentence because they've clearly already made their mind up, and that ideally you would want to get that case as far away from that jury as possible and let the judge do the sentencing. However, in Texas, if you ask for a trial by the jury, you also get sentencing by the jury. But in Texas, jury sentencing, whatever sentence they want to give, must be unanimous. If even one of the jurors does not agree on the sentence, then what happens is you actually have a mistrial. You have a sentencing only mistrial, which means they dismiss that entire jury. They do jury selection all over again, which means here, if they were to do that, there's a chance you could have a Black person on that jury for the first time. And therefore, you'd have a whole new jury, and then that jury could would determine the sentence. Now, what's the sentence range? Here, the range, because it is M1, is 5 years to 99 years. That's right. It is 5 years to 99 years is the potential sentence. There is no room. Oh, no, correction. However, that is incorrect. It's actually probation to 99 years. Here's why. So Texas updated the laws a few years ago where now, if the jury were to determine that his sentence is 10 years or below, because he's never committed a felony before, the jury would have the option to sentence him to probation. They're not. The reason I say they wouldn't do that is because, and I don't think they would do that, is because they had both murder one and manslaughter on the table that they could have selected from. The difference between the two is that manslaughter meant that they felt he wasn't intentionally trying to unalive this young man, and that instead it happened recklessly because he was acting unreasonably, but recklessly, and not intentionally causing the unaliving. they declined to find him guilty of manslaughter. They found him guilty of the murder, which means they believe he did it intentionally or knowingly. So therefore, they're not going to give him probation. So if they would have sentenced him to 10 years or less, then they could say, Your Honor, we want to offer him probation. But that also says to me, they are likely going to give him substantially more than 10 years. Now, it's alleged that the prosecutors offered 40 years, that they offered specifically 20 to 40 years, and that that was declined. So a win here would be a sentence under 20 years. 20 years or less would be a win. Now, in Texas, you're not eligible for parole until you've completed at least 20% of your time. But the jury's not allowed to consider that. So it's crazy to me that a jury is, when you get in there in deliberations, I've been on jury duty before. Actually, before I became a lawyer, they let me on there. I actually did my law school personal statement on my experience doing jury duty, and I got a full ride to law school, as well as the school I went to. I didn't have a full ride. I went to Cornell Law, but I had most. All right, we've got some guesses. Put your guess in the chat of what you think they're going to give him. So in Texas, they'll tell the jury, hey, you have to set your sentence at whatever you think is fair, but you're not allowed to consider the fact that he, after serving only half of the time, he could be paroled. And you're not allowed to consider that in your sentencing, because technically no one has any control over that but the parole board. So I've always thought that the law should be changed. I thought that it was ridiculous that you tell jurors, hey, they could get out in half, but then you tell them, but you're not allowed to consider that in sentencing. And if you do, that is one of those offenses where, if it could be proven, it could warrant a new trial for sentencing. That's how big of a deal it is. I anticipate that they're going to give him 20 to 40. I think they're going to give him at least 20, because I think they're going to think in the back of his head he could get out in 10. I also think, they're going to do it from the perspective of, how do you say? Oh, hold on a second. I see it looks like there could be an update. It says starting at 7 p.m., there's going to be some coverage on Channel 4. Let me just put that in the corner so we can stay abreast starting at 7. This is just coverage. This is likely for Channel 4. It's likely them recapping it. But if they cut to making it appear as though we have information on sentencing, I'm going to cut and share that immediately. So don't worry. White Jodeci said, damn, I thought he was going to get like 15. 40 is a lot. Don't trust any of these people. But didn't they already make an example out of Austin? Not sure what that means. Don't watch Fox News. I don't like watching them either, but they're the only one right now that appears to have some level of live on the ground coverage there right now. So, okay. So I know there are a number of people who felt that he should not have been found guilty at all, but you have to remember, I'm from Dallas. I'm from DFW. I have always, I've spent time in Frisco, their police department, they're all of that. It disgusts me. I have seen them across the board mistreat whites, particularly poor whites, specifically whites who were not part of the establishment, you'll say. Because Frisco is one of those, Frisco and Collin County, they're one of those old towns where you have a lot of older money people where they had their land when it was nothing. And you could not even have forecasted what the values of the properties and things are worth now. So, you've got what Dave Chappelle refers to. This isn't funny, but when Dave Chappelle does his skit, if you've ever seen it, what Dave Chappelle refers to as, you've got tiki torch whites. Okay. You've got some tiki torch whites out there. And then you've got what I call the California LA whites. So what I'm saying is, everybody there isn't bad. Of course, nowhere is everyone bad. Is she a lawyer? People like this are why Karmelo is getting 99 years. Okay, sure, whatever. But what I'm saying here is that I knew that it was going to be an uphill battle based on the demographics of the town, right? But I didn't realize that it was going to be as ridiculous as like not a single Black juror. I have a video on that and on that breakdown. But more specifically here, right now, what we're dealing with in Collin County is growing exponentially, and they want to ensure that people have a positive view of Collin County and that it's not associated with, a high school track meet murder. Like, no way, Jose. That is the opposite. Hold on. Let's listen to what the breaking news is.
And we can tell you the jury at 6:15 tonight ordered dinner. So Judge Roach had said they could go earlier. He said they could go as late as 11 o'clock at night. We don't know if that means they are
Okay.
going to go that late or if they're going to have dinner and then
Yeah,
come
hear
out
it.
with what they've decided.
So there was lunch today, and not long after, they came back with the verdict on the guilt and innocence phase. It's possible that same thing could happen after dinner as they work through dinner
Yeah.
and then, come to a conclusion on the punishment phase, how many years will be assessed between now and 10, 9 o'clock even, or later.
And they did bring their clothes with them, so they could be sequestered if need be.
Right. That's another level of pressure, psychological pressure
Yes.
on a juror.
It is psychological pressure.
You're away from home.
Mm-hmm.
You can't talk to your family members. You're in a hotel room, and all of us have traveled. The first night you're in a hotel, you don't sleep well anyway. And now you're in a hotel room, and you don't want to really be there. And the
Yeah.
weight of this decision that is yet to be made is on you as you struggle with that overnight. And you're only supposed to deliberate when you're in the jury room. So you go back you go to the hotel, but you can't talk to the other jurors about this case. And you can't watch the news.
Nope, no social media.
Right.
And it's the issue is sudden passion. If it's sudden passion, then is it 5 years, 20 years?
20 years could be the maximum on a sudden passion.
But if not sudden
Or
passion, it could be 5 to
it
99.
could be life. It could be
Yeah.
the upper end of that 5 to 99 years. And so maybe they're arguing or disagreeing or struggling to answer the question, do they find sudden passion or not? The prosecutors, Bill Worski, said this is not sudden passion. You can't find sudden passion. Basically, he said, this is not sudden passion. This is murder, and life sentences have already been handed out. And you need to give a long sentence to show that we don't tolerate senseless violence here in Collin County. There's a lot at stake here.
Definitely. And Sean, as we take a look outside the courthouse, this case has gone international. It's gone national. We've seen people.
All right. I have it muted because basically they have confirmed that the jury, what they just confirmed is that the jury is at their hotel and they just asked for dinner. The jury is sequestered in a hotel and they can't leave until they come up with their verdict. However, they are, the judge said that they can contemplate up till 11 o'clock at night. Obviously, if they agree on the sentence by 11 o'clock at night, he could do it one of two ways. He could say, okay, write down this. No, I don't think he'll let them go home until the sentence is announced in court. But it sounds like up until 11, they are able to continue deliberating. They ordered dinner, which means they're getting comfortable and they're trying to knock this out today. So when you think about mentally, it makes total sense. These people have been every day working on this since basically last week. It was last Tuesday, I believe it started. And they even had to go to court and hear testimony on Saturday. That's how much they, sorry, let me get this one. Hold on, wait. That's how much they've been focused on this. Oh gosh. Hold on. I'm trying to find. Okay. Kenny, I made you one. I just made you a mod, so I don't know if you got that. I'm sorry, Kavani Elaine, I just made you a mod, so if you can see that. I'm looking at this commentary. Okay. But I want to read to you. I'm going to read to you. This is from CBS. Hold on. I want you to understand kind of how they are going to deliberate on the sentencing options. It was, here we are. I'm going to pull that back up. I just had it. Here we are, the live updates. All right. What do you want? Hold on. Okay. So we've got, I'm just making sure we've got, okay, we didn't miss any of these updates. All right, so here there were jury instructions. This is what matters. This is what the jury is going to be considering in the sentencing. So under the jury instructions, they included the issue of what's called sudden passion. If the jury unanimously, take this off, if they unanimously find that the defendant caused the death under the, quote, immediate influence of a sudden passion, he can be sentenced to no more than 20 years, but no less than 2. That would make it manslaughter. Okay, if the jury unanimously finds the defendant did not cause the death under an immediate influence of, quote, sudden passion, he can be sentenced to life, but no less than 5 years. In either case, he can get a fine. We don't care about that. As a fine is the least of the worries. But the sentence may also be reduced by parole. We already talked about that. That's not happening. However, the defendant is not eligible for parole until the time served equals half of the sentence imposed, or 30 years. Okay, so I did say the half part, or 30 years. So obviously if it was like a 60-year sentence, he'd need to do at least 30. And whatever the sentence is has to be unanimous. So when I talked in a previous video about a panic response, that panic response would be consistent with finding this was more of a sudden passion. The problem with the wording sudden passion just doesn't fit at all. First of all, sudden passion sounds more like something that would apply if it was I walked in on my woman cheating with another man and then I killed him or her or both of them. Sudden passion in this context, there are equivalents. I don't have the wording that the defense used, but I hope that they crafted it in a way that basically would communicate it's more of a panic response. It's more of a I suddenly reacted and responded, because keeping in mind we're dealing with 2 teenagers here that are idiots. Teenagers are idiots. This is not specific to Austin. This is not specific to Karmelo. They're idiots, which is why they are not allowed to even sign contracts at that age. Someone asked, can you address if I think, hold on. If I think some YouTubers spreaded misinformation. To be honest, I only followed Queen Sheba and Nick at Night. I did not look at some of the others, so I can't speak on whether others were spreading misinformation. Oh, I got it. I made you a mod. Thank you so much. And thank you for that super chat. I apologize for taking so long. Thank you, W. Brizzle. I really appreciate that. We're going to do some questions. Oh boy, we're going to answer some questions on here. There are a lot. It's moving through quickly. Let me tell you what I think the sentence is going to be 20 to 40 years. I think it may be around 25. Part of it is that I think that the jury is going to consider that after serving half the time, he can receive parole. I also think that they're thinking, oh, he took a life. That's standard that people say, oh, he took a life. His life should basically be done too. And I think if you think of a 17-year-old 20 years from now, that is the majority of their life. I anticipate, I don't think it's going to be 40 years, but maybe they want to send a message. I'm not sure, but my guess would be the 20 to 40 range. And that is around allegedly what the state offered as a plea. And then we also have here, Symone, can I make you a mod? All right, let me look for you, Harlem girl. Thank you so much. And then we're going to do it. Can you make another comment? That way I see yours and can immediately like tag you to moderate. Oh, I got a 20. Oh, thank you. I got a $20 super chat. Thank you. I'm going to be rich. Man, I'm going to buy some new drawers with that one. Inside, that's an inside joke. Hold on. Thank you so, so much. All right, Harlem, I hope you see that comment. There we go. Okay, I see you there. I see you. Good. So now let's get into the nitty gritty of this. Great. Let's go back to answering the questions. Okay. This one I really want to address. This is, I'm going to take this down. This viewer has said, this was a clear-cut case. I don't know why people think self-defense was going to fly. White Jodeci, as a lawyer, I'm with you. Here's what I think happened. As lawyers, we work with what we got. We work with the truth. We don't try to lie, create truth that isn't there. Here, this really the main thing that the defense had because of the fact that Karmelo admitted that he did it. And then he even said, on the scene, he said it was self-defense. I always thought from the beginning that wasn't a great argument. But sometimes what happens is you take your strongest argument and you try to use that to get a reasonable deal. I think that if Karmelo's attorneys had a reasonable deal on the table, we wouldn't be here. They had a reasonable deal. They probably would have convinced him to try and take it. The challenge was, my understanding is that the deal on the table was approximately 40 years. What would I have done differently as his lawyer? Great question. I'm going to start so I don't lose it. If you're new here, I've got ADD, so there's that. I'm going to see if I can find that question again because there's a lot in here. What would I have done differently as his lawyer? So it's hard to say, but it's hard to say what I would have done differently because unlike I covered the Diddy trial, if you watch my coverage there, it was in the courtroom daily. And in the courtroom daily there, you were able to hear objections. You were able to hear motions. You were able to pull documents, read motions, and get an understanding of what was going on, not just the testimony, but behind the scenes. So I also had a strong understanding of what evidence we were not permitted to see. Here, that wasn't the case. There was a gag order. All of the motions that talked about what evidence would be excluded, those were all done prior to the start of trial. There were a number of sidebars. The documents are not put on the record. So one of the main complaints that people have about how this case was handled was that they feel like shady business was done. At this point, federal courts we know are not televised, but most state court trials that are high profile, they get televised. So people were wondering, what the hell? Why wouldn't this judge allow cameras in the courtroom? Why wouldn't you allow transparency? Now, I have to say, this judge is trifling. Judge Roach, if you're watching, I think you're trifling. If you don't know what that means, go ahead and look it up in an Urban Dictionary. I'm going to tell my story of being before him in a moment. But the point is, because when you ask me what I would do differently, it's hard to say when I can't even tell what was done. And part of the reason we can't tell what was even done is because the judge blocked us from that. The judge is not allowing us, for example, every trial has something called motions in limine. Motions in limine are basically motions where beforehand parties argue about certain things that can go before the jury. So, for example, it is common, I don't remember which case it was, but there was a high-profile case recently where the state argued, or the defense, the defense, this was the Diddy trial, the defense argued that some of the S workers, some of the prostitutes, shouldn't be referred to as victims. That was an actual motion, because in front of because once it's done in front of the jury, it's hard to undo. So you'll have a motion that says these are things that cannot be said in front of the jury. One of the sets of motions that I know for certain occurred is motions that would have defined what information the jury could hear, if any, regarding the brothers' prior incidents of fighting or violence or getting in trouble in campus activities. Now, the judge limited that profusely. We didn't hear any of that. Part of the reason, or some of the grounds that judges may use, is that if Karmelo wants to argue his fear was reasonable under the facts, the judge may say, well, you have to show us that Karmelo knew these guys were violent beforehand. So, for example, that might have been conversations like Karmelo and him played on opposing football teams. It could have been maybe Austin had gotten in a fight with one of Carmelo's friends and that friend got beat up real bad. We didn't hear any of that. And it very well could be we didn't hear any of that because it never happened. Okay, first and foremost, that very much could have been the case. It never happened. But also, I say that, but also, that's why it's important to have these type of motions on the record, because if there were motions like that, and allegedly there were some, where they wanted to bring into play Austin's prior history of getting in trouble or getting in physical fisticuffs, and the judge was like, well, you can't prove, you guys, this isn't relevant, or this is more prejudicial than probative, different issues like that. In the end, those are all the things that if they would have not had a gag order, the public could see and gives the public more confidence in the ruling. So when I say, what would I have done differently? I really don't think these lawyers had much to work with in the beginning. I mean, in the first place. I don't. For example, if Karmelo had not said, well, this was self-defense, I think they still would have attempted some type of self-defense argument, given that a weapon was used. But I think that if these weren't children, it would have been easier to get some sympathy for a self-defense argument. The problem is you've got parents. Parents are protectors. When you have parents as jurors and you've got a kid that stabs another kid, you've got parents that are like, well, wait a minute, I don't want my kid to get stabbed and the other child be able to get away with it by saying, well, my kid shoved them. You know, if my kid isn't actively fighting them, then, excuse me, I need there to be justice. Hold on a second. Thought that it was intentional, no media. So with the no media, I think what was going on is you have to remember, in Texas, judges are elected. This judge, Judge Roach, he goes up for election every 4 years. If someone can Google it and let me know, put it in the chat. I don't know if he's up for re-election this term right now, as in November, or if it's in 2 more years. But they go up every 4 years. And if you remember, initially, Karmelo wasn't given a bond, or it was given like $1 million bond, and then it was lowered. And he was able to or I think he was given no bond and then it was lowered. Whatever it was, the second go around, he was able to meet that bond. It was an African-American judge that lowered that bond, and people sent her death threats and all types of things. I say that to say, when you're in a smaller town like this, so Frisco has grown, but it's still small compared to Dallas. You know, and Judge Roach, his family has been in Collin County for generations. In the back of your mind, you know that your decisions are going to impact whether you can go to your local diner, your local eatery. Your life is going to be dramatically impacted by the case. So he may have thought that by putting a gag order, it's going to make life easier because of how volatile this case has been from the beginning. And let's be clear, it was volatile based on race. There are Caucasian people who felt like the blacks have come in our county and they are running amok. And then there were black people who feel like this young man has been overcharged. Yeah, someone said they have a school named after him, as in the Roach family. It's probably Judge Roach's dad, because I believe his dad may have been like a district attorney or something like that. But yes, the family is very entrenched. Let me tell you about my personal experience with Judge Roach being before him, and why I say I feel he's the worst judge in Collin County. I've had if you Google me in Collin County, I've had very famous case in Collin County where there was a corporation that was headquartered in Frisco. And that corporation, they threw millions at it. Jerry Jones invested in that corporation, gave him $5 million. The city gave them like $10 or $15 million worth of real estate because they were a medical device company and they were expected to become, the plan was that they would be the anchor to develop a pharmaceutical corridor for Frisco. For Frisco, Texas. How the way Frisco is so rich and they've gotten so much money, they even have a Universal Studios coming in, is because their city planning model was that we're going to entice corporations to relocate their headquarters to Frisco by giving them tax incentives for, like, let's say 10 years. Because if you do the math, when they come here, they bring business, they bring their workers, the workers then buy homes and infuse so much money and tax income into the economy that it is more than worth it. So, for example, they got Toyota to move there from California. They got Liberty Mutual. They got Toyota, Liberty Mutual, others, and they've infused so much money that Frisco is extremely wealthy from doing that. Well, this particular company, this particular company was supposed to anchor a pharmaceutical corridor. So think of, like, in New Jersey, you've got Johnson & Johnson and Eli Lilly, and you've got all of those companies that are there in Jersey, and they have their headquarters and they bring so much money to New Jersey. Frisco was trying to replicate the same concept, and they used this company and they did no due diligence. This company was making a deadly product. That deadly product killed my client's a little girl who was a kindergartner at one of the Frisco ISD schools. I ended up suing that medical device company. I told the FDA, I brought the FDA all of the evidence of how deadly that company's medical device product was, how it had killed my client's child. This was me as a solo practitioner, baby lawyer, by myself. And the opposing company, again, that was Frisco, gave them millions, gave them everything. They did everything to bankrupt me. They accused me of extortion, defamation, all of these things. I stood 10 toes down. I ended up bankrupting them. They are actually bankrupt. Jerry Jones gave them $5 million. They were publicly traded on a stock exchange, etc. Well, in the course of that, portions of my case were in front of his court. The judge was just very much lollygagging. He was giving that company, like 2-3 shots at the apple. The case should have been absolutely, like, summarily dismissed initially, because what they did is I filed my lawsuit against them, let's say in court A. And then they filed a whole new lawsuit accusing me of defamation in court B. And rather than that case, the judge should have been like, oh, this case needs to be moved over and be in front of the same judge. He did not. So that was like the first melee as part of that. But that was also my first experience dealing with Collin County courts. But the bigger issue that I had is I was representing a gentleman who, this was a standard motion. It's called a default judgment motion, right? There was a default judgment motion. The client was never served. And this was an attempt for the HOA to take his house for unpaid HOA fees. Now, it's standard that when you have a case where your client has never been served, you just go to court. You say, hey, Your Honor, my client hasn't been served. They served his ex-wife, not him. This is the proof. They didn't serve him. They served the wrong person. We're here now. We're just asking that you give us like 10 days for us to file our answer, and you set aside the default. I have done this in my sleep. I've done this probably 25 times. 100% of the time, every time I had proof that the client wasn't served and that someone else that wasn't the client was served, the judge is like, okay, we'll give you 5 days, we'll give you a week, whatever. Well, in this situation, Judge Roach was like, yeah, your client was never served, but basically the entity that was against my client was entrenched in Frisco. They were very a multi-million-dollar entity within Frisco, Frisco, Collin County. And so the judge just refused. He was like, no, we're going to let him take your client's house. I was like, what the hell? This is literally a default motion. If you're an attorney in the chat, you know how simple it is, like default motions, just getting them set aside or like a common thing. But apparently he very much leans towards businesses and corporations that are Collin County leaning. That's just what he's known for, which makes sense because that's how his family pays their bills. Ultimately, my client appealed it and it worked itself out. But my point was just, in my experience in talking with my colleagues that practice before him, he very much leans towards like the entrenched within Collin County. So by entrenched, I mean, do I want to say the good old boys? I'm not going to use that word. Not going to use that word. Somebody said, just got here. Is she on the whites or the black side? I'm on the side of justice, and effectively here, under these facts, what we're talking about now is we're waiting on a sentence. The jury has said that the jury has just ordered dinner. They just ordered dinner. They're deliberating. The judge said they're allowed to deliberate until like 11 o'clock at night. Hold on one second. Yeah, they're going to be deliberating until about 11 o'clock at night. If they can come up with a sentence that they agree on, they will do so. Although probation is an option, I don't see that happening, because if they were going to, probation is a form of leniency. If they were going to be more lenient, then they would have likely gone towards manslaughter, but they in fact found him guilty of M1. However, here with the sentencing, they can choose to do 2 to 20 years. I think they're going to be more along the 20-year range. I'm expecting like 20 to 40. The reason I'm saying that is because they're allowed to know that he can get parole after serving only half of the time. And so sometimes what happens is a jury will give you 40, knowing that you have the possibility of getting out after 20. What sentence in the chat do you think would be fair? That's what I want to know. Hold on, we got some more starred here. So we've got Fire Only Vibes. Thank you so much. Judge Roach is retiring at the end of the year. I bet he is. Oh, thank you. Someone says they have a decision on sentencing. Let's move over. Hold on. We've got the verdicts in.
We get to the punishment phase, we're really just talking about what is an appropriate punishment for this one individual in terms of how they live their life and where they might go. And so there's a huge difference in the analysis, right, between do I find this person guilty or not guilty versus if I found them guilty, what is an appropriate punishment understanding this whole person's life? And so you're exactly right. It's a totally different analysis. And I'm hoping that this jury feels, sort of given the tools and feels confident enough to be able to say, okay, I understand what my role is here in the punishment phase, that it's beyond just this moment in time. It really is the entirety of Karmelo Anthony.
Right. And there's not a lot to look at. There's no juvenile history. There's nothing. I mean, again, sometimes it's easier if I'm a juror and I have someone sitting in front of me that has this long history of doing bad things. It's easier for me to come to some conclusions about how long that person should be put away. And maybe that's part of what we're going to find out tonight when we hear what their final decision is, because there wasn't a lot to look at in terms of a bad history. The kid didn't have that. Neither one of these kids had that.
Right. But that in and of itself is significant, right? Like, so if it's easy to say, oh, I have this long criminal history sitting in front of me, that makes it a little bit easier for me to understand that this person is maybe generally a bad person and therefore they deserve more.
Okay. So they haven't, they don't have a sentence in just yet. They're just talking about it. The verdict is in, right? But they don't have a sentence yet. That's why I just muted that. But I haven't heard much discussion though, about the fact that it was one stab. I think that one stab should be a focal point in the sentencing. Y'all let me know what you think in the chat, but on the defense side, that's what I would be focused on. It's also why I felt manslaughter or a sudden passion explanation could be supported by the facts, because one stab, he runs off, right? So if if he had an unreasonable concept of fear, right? So that's how come it was considered murder. Is no, his fear of Austin was not reasonable under the facts, is believed. So, okay, if it was unreasonable, but the fact that you stabbed him once and then you ran, and it was my understanding as well, he was sitting, Karmelo was sitting, Austin was over him. So I don't know how the motion was done, but either way, he stabbed him once and he ran. I think that it makes perfect sense that they say, okay, we want him to serve prison time because he shouldn't have had a knife. Now, it is not illegal. The knife was not illegal, but it was against school rules. So that matters. He was breaking a school rule. That is correct, but it was not illegal. Oh, thank you. Hold on. Thank you. Okay, it says it's 7:05. All right, so we'll keep this up. I'm keeping the box up with box 11. It says the sentence verdict was reached. Jurors reached a sentencing verdict after about 2 hours and 20 minutes of deliberating. The court is expected to resume in about 20 minutes. This is okay from the Metcalf family. I'm not moving. No, Janine, it says one stab but turned the knife. Boo. You may have heard that, but I also think, like, I think that's a better satirical, like, I think that goes to show, like, kind of how crazy the different versions of the facts have become in this, because there's no way in the melee of what was happening that anyone could confirm that. And I didn't hear any testimony of that. He did show remorse. Okay. Symone, what criticism, thank you so much for the super chat. What criticism do I have with the defense with how they characterize Melo or the lack thereof? Is it possible the defendant didn't have the funds to call experts or psychologists, and that's why none were called? No penny. Oh, let's talk about it. I hate when defense attorneys do not call experts. I despise it. I have seen some lazy lawyering that does that. But here, what's challenging is, okay, so I don't think it was a money thing because they raised $600K. We got the sentence. 35 years. 35 years. 35 years. I told y'all.
Now, and I will tell you, in my 17 years, I think these set of facts, a jury coming to the conclusion that 35 years in prison is an appropriate sentence, is quite incredible. It's quite incredible. I'm slightly blown away. I will tell you that it's important that we always remember here in Texas that you have a range of punishment. The range of punishment for a murder conviction is anywhere from 5 years to 99 years or life. And regardless of the sentence that you receive, in the state of Texas, you are required to serve half of your sentence or 30 years, whichever is less. Mm-hmm. So in this particular instance, he's sentenced to 35 years. Before he becomes eligible for parole, he will have to serve half of that sentence. What is that? 16 and a half years, 17 and a half years?
Roughly 17 and a half.
Before.
Yeah. And that may very well have been the age of Austin Metcalf when this happened in 2025.
I think that
17.
I think you're right about that, Sean.
Absolutely. Absolutely. I'm actually surprised differently. I again felt like it was going to be longer. I just did, based on I know Bill Worski was asking.
What he called for.
Yeah, he didn't give them a number. He didn't assign a number in his closing statements in the punishment phase, but he impressed on them that it should be lengthy, that it should be long, that we have to send a message of we're not going to tolerate senseless violence in our community. He talked to those jurors about them coming together as a community to do the right thing, to serve justice. He put on those jurors the idea that they were upholding the standard for the community. And so I thought it might be longer. I hope we get to hear from the jury foreman or one of the jurors at some point to know what they were thinking and what they went through in that moment. So I guess the word is now spreading to those outside of the courthouse.
It does look like people are looking somber. They're looking very, very astonished.
Just getting that information. I said it in my reel this morning. I thought 20 to 40. I
have no idea who those people. I don't believe they're any active part of what we're experiencing here. This could very well be some media. Again, the media from everywhere in McKinney for this.
Yes. I mean, it hit obviously the national news. And I just want to make one comment about one of the things that jurors are instructed to do as it relates to assessing punishment. Obviously, it's a standard prosecution argument in punishment to say, this is our community, sort of don't stand
they are
for
sending a
senseless
message,
violence or whatever it is in our community. This is where we live and all that. Send a message to, this defendant and the community at large and all that kind of stuff. And that's a standard prosecution argument. But the other thing that a jury is also told is during those jury instructions, when they're being read to the jury, they are told that they cannot consider, they can understand the existence of parole law, but they cannot consider it as they contemplate an appropriate sentence. So in other words, it's interesting to me that it's 35 years and that half of that, which is what he would be required to serve before he's eligible for parole, is about 17 and a half years. And that is likely the age, right, that Mr. Metcalf was when he passed away.
I told y'all.
And I wonder whether or not that jury, even though they were instructed, they may have taken that into consideration.
I certainly think that's a possibility of the age piece.
Let me tell you, one thing I know is I know humans and I know the law. So you don't have to agree with me, but I be smart. I said yes, I'm exhausted, I'm tired, and I am code switching. Hello, my name is Cornell. My name is Symone Redwine. I'm an attorney and I graduated from Cornell Law with honors. So fuck you if you don't like it when I code switch. But what I am saying is, from the beginning, people were like, it's self-defense, it's self-defense. I was like, not in Collin County. We need more. And I hadn't seen the more. Not in County. Even when I did my breakdowns that I've done on this case, that previously, you will see I did not give a self-defense analysis. I gave an analysis of murder, of panic, and the potential of manslaughter. But I specifically said, I think they're looking at 20 to 40 years, thinking they want him to serve 20, but they're going to consider the fact in the back of their mind that he could be out after only doing half of the time. That makes sense. And then they did the 35. Now, that is unlawful. You're not allowed to do that as a jury. You're not allowed to basically come up with a sentence and then come up with the sentence and double it. But how do you prove that they did that? You didn't. You can't. It's just very interesting to me that I feel like this is the same sentence that they give someone who stabbed someone repeatedly. It just doesn't seem that they took into consideration at all the fact that it was one jab and a run, that he was hysterically crying, and that afterwards he was even in denial when his coach was basically saying, you better hope something along the lines of hope, pray that he's okay. And he's like, he's not going to die. He's not going to die. He was that clueless. I called it word for word down to the jury considering parole. Thank you, Kitty Boo. I sound like my mama when I say this. I don't like being right at some of this stuff, But for those who, like, I respected people's listening to people's opinions who were confident on the self-defense, but what really matters here is that you had parents. These are parents who are on this jury, and parents, one duty is to protect their children. Let's also talk about the jury. See, up, this is my girl. Hold on.
Preserve that error. We have to file our
That's
notice of
Velma.
appeal, because if there are things to appeal, we have a time frame under which we want the courts to know that that's what our intention is. And so you're having a discussion about what are our next steps, and you're obviously encouraging your client. And I've been in this position before. I've been doing defense work for a number of years. You're also encouraging your client not to give up hope, right? That there is hope still. They have to keep their head up, that this is not over, and that you have to keep pressing forward.
Okay, now put your prosecutor hat back on, because what are you saying?
Apologies, guys. Apologies, guys. We are back. Hold on. My damn internet. Hold on. Sorry about that.
Happening to them right now. Who could be talking to them right now?
Sorry, we got it.
Generally, what you see is that once a jury reaches its verdict, they're obviously released from all of the rules, right? They're released. They can talk about the case openly now. They can talk to each other. And generally, you're going to have the judge that's going to go back and talk to them privately first, right? To say, okay, thank you for your service. You're released from everything.
I have to tell you guys, I'm very shocked at how quickly
specifically for Judge
all
Roach,
of this happened. That makes me think they have
you are
already
now
come to their
free to talk
conclusions
to whomever
a
you
while
want,
ago.
and that includes
Very
the
quickly.
lawyers.
Very,
and sometimes
very
the lawyers
quickly.
would like to come back and talk to you to ask you kind of what did you think? Why did you arrive at your decision? What were the things that that were highlighted for you? But the judge is also going to tell them that they don't have
My favorite.
to talk to
True Advocate
anyone.
says you're not
and so
black.
for the jurors that
Blacks
don't want to speak to anybody,
announce
which
their
usually is a lot
race.
of them, right?
I don't know if you're talking to me, but I remind people all the time. You know why? Because people ask
that
me
the jurors come through to
all
make
the
sure
time,
that they're
or
safe as
because
they're
I
coming
am
and
so
going from court.
brilliant.
So I would imagine that
some really ignorant people will say, "Well, you're not even that black." That's my favorite, since all of my grandparents are black, so I know they're stupid. But here, many have asked, like, what would I do differently if I were on the defense side? I really think the defense just didn't have good facts to work with. It wasn't self-defense from the facts that I received. Even at the beginning of hearing the facts of this case, I was like, I think, okay, I thought that a better position on the case would be, we want to make sure that there's fair treatment of this child based on the facts. We want him to be treated fairly, not punished more severely because of his race, but punished the way you would punish any rich white kid who did the same thing. I think that is the approach that I would have taken. But I also think that the attorneys that came in didn't have much to work with, but someone had asked, oh, that was a question on the floor. My apologies. Why no experts? Why didn't they put money towards that? Here, let me put that back up. Specifically, what criticism do I have of the defense of how they characterize Mello, or the lack thereof? So from what I was seeing, there were complaints that they did not that their cross-examination wasn't hard-hitting enough. And when you're cross-examining children, teenagers, they're not babies, they're teenagers, you can still go at them. So for example, I was surprised. I watched a recap from Nick at Night. She talked about how when they were discussing that the prosecution had elicited that because it was raining, Carmelo and his friend went to the dugout, and then a coach in the dugout said, "Hey, you guys have to leave." So they left. So the prosecution used that to highlight that when they were told to leave, they left. Therefore, why didn't they do that in this instance? Well, that would have been a time for the defense to establish the difference between being told by your coach to do something, an adult, versus a peer when you had already been invited by another schoolmate to sit in that dugout. It was also difficult. This was really hard for the defense as well, because every single witness who was there was from the other school. And one of the kids' number one fears, right, is being ostracized by your peers. This was also, I believe, would have been graduation year for many of the students. Like Austin, I think would have graduated last year, but some of the other students, basically. Okay, I'm back. Apologies. Apologies, guys. This Bali internet is. I'm gonna have to do something about it. That's how come I've recently done a lot more pre-recorded videos, because it is just that much garbage. But the point was that with the defense, they had a really difficult uphill battle because all the witnesses were friends of the victim. They went to school with the victim's brother. And if they were to say anything other than the testimony that they gave that was supportive of the victim, their lives would be hell. Their lives would be hell, the lives of their parents. Hold on, let's see if we can hear some of the audio here from out front in the courthouse. Yeah.
And they not have been able to consider how long this
Uh-uh.
sentence would be, but
Yeah, I really
or how
think
much time would be served.
my friend Lori Bay, from the Black Lawyers podcast, she said, she said they already had that sentence ready to go. I agree. The way that they ordered dinner and then boom, they had their sentence. They knew what they wanted. And I will also say, Ayana from Oakland has asked, is it possible the defendant didn't have funds to call experts? I appreciate you guys in the chat. Someone in the chat had the money that they had raised was frozen. So that could entirely be true. Now, what happens is if you can't afford it, you are supposed to make a motion to the judge asking for money. In the same way, that you get a court-appointed lawyer if you can't afford it, you're supposed to make a motion to the judge asking for money for an expert. But the truth is, if you already have a private lawyer, judges are they're unlikely to give you money for those experts. But you always want to put on record that you asked for money for an expert and the judge didn't give it to you. Because I have seen, when I was in law school and we worked on appeals, I have seen appeals granted, new trials granted, where defendants were denied money for experts in things that they would have needed to prove out their case. And no penalty phase statements. Now, I was not aware of that. Because you should have had a whole bunch. You should have had a pastor. You should have had Okay, Marie James is saying Mike Howard was appointed to him. That could very likely be because he has both. His lawyers were Mike Howard and Toby Shook. If you Google Toby Shook, he used to be the head DA, one of the head DAs for Dallas County. So that would make sense. But no penalty phase statements. If that is true, that is absurd. No penalty phase statements. So the mom talked. Was there anyone other than the family? So, for example, I'm not sure because all this happened very quickly. Again, I'm 13 hours ahead, so I was asleep until now. Right now, it's like 8 in the morning here. Did they have a pastor come? Did they have coaches come? Did that happen? Thank you. All right, thank you, Marie. All right, Marie corrected it. Said that the mother spoke. Only his mother spoke on his behalf. Well, then that's definitely something I would have done differently as a defense attorney. Number one, I would have challenged some of the incorrect like versions of the facts that the defense, I'm sorry, that the state witnesses had given. I would have also focused on Eddie was the alleged friend that Carmelo went over there, like Carmelo noticed him under the tent and went over there to sit with Eddie. But then on the stage, Eddie very much distanced himself. I probably would have tried to do a stronger job of crafting the narrative that Eddie is distancing himself as a result of the community pressure. Not because it didn't happen, but because Eddie's got to graduate with these people. Eddie lives in the neighborhoods with these people, those kinds of things. Because I think people can relate to that. It's kind of like the whole, you don't rat in a community that you live in because then you got to watch your back. Yes, great question. Why now lounge? Why didn't his own coach? You got to get some coaches up there. You need coaches. You need Jesus. You need um, business, but pastors, all of yeah, it's sad. Only the mom spoke. Hold on, I have some notes here. So, for those of you also who are questioning and like, what about experts? I so one area that perhaps an expert could have been used would be to talk about the psychology of a child that is in that environment and how basically use it to get. I don't think you could get a. I think even with an expert, I don't know that you could have gotten all the way to a self-defense verdict, but I think with an expert, it would have given more grounds for something closer to a manslaughter. I also don't think enough of a story was crafted to get a lower sentence. That would have been more in my mind. I felt like a 10 to 20-year sentence would have been sufficient to give a message in this type of under these facts. But clearly that wasn't the case. All right. And then we've got here. Do we know if a request for change in venue was made? Great question, fire vibes only. I think about that all the time in this case. It's unclear if that was asked for, but that should have been first and foremost. But the state would have fought that left and right. So usually in Collin County, when you ask for a change of venue, it changes the venue to Dallas. Now, what they're able to do with change of venue, you still have the same jury pool. You just have like the environment would be Dallas County. No, that's not true. Um, I have to hold on. I have to confirm that. Yeah, no, it would have been a Dallas County jury. There's no freaking way. It would have been a Dallas County jury because Dallas County would be the nearest large county that could have. Y'all double check that for me, but I'm pretty sure it means the jurors would have had to come from Dallas County. There's no way they would have allowed that because Dallas County jurors would have been too black. That's just the truth of it. That's just the truth of it. Yeah. Interesting since Frisco also borders Denton County. It could be Denton County. Actually, they would probably be okay with it going to Denton County because the Denton County demographics are more similar to Frisco. So I could see that happening. Can he be released earlier than half the sentence for good behavior? Um, I'm not for sure, but I believe there are some good behavior calculations that could go in there. But I'm not completely sure. But I'm fairly, unless because I think good behavior goes towards the calculation of your time, of how much time that you serve. So that's a good question. So, for example, like I know, so in Dallas County, the Dallas County local prison that they hold you in before trial is so trifling that for every day that you sit there in Dallas County, it counts as 3 days of actual time. So I don't know if it works something similar like that for the release time. Oh, Ayana says the mom was asked 2 questions only. The state crossed her. Both the state and the defense waived opening statements during the penalty phase. Child, what? Thank you for letting me know, and thank you for that super chat. Waived opening statements during the penalty phase. That sounds like everybody felt like the jury already made their decision. Because that sounds crazy. I don't understand why the defense would waive an opening statement in the penalty phase, because especially if the other side was, because that's the defense's last chance to say, hey, this was a good person. Here's why. This was a mistake of an irresponsible child. This is a remorseful child. Because he seemed extremely remorseful. Now, I would have cried in that courtroom. He would have been shedding tears and wiping them because I know he wanted to. I'm sure he probably wanted to. That sounds crazy. Oh my gosh. I wish this case would result in parents talking to their kids more, regardless of race. I can agree with that. And I think you really need to let our kids know, what does self-defense really look like. Let's talk about, when you get in these kinds of things, what are your rights? What are you not allowed to do? Because I have to say, I don't understand. And I was talking to my mom about this, how a young man could think you get shoved one time, you can use a knife. I don't know how to make that argument. I could totally see it if he was being punched, if he had already been hit. But you got it. Someone disagreed with me in the comments. He was like, I liked what you were saying until you said that he needed to get his butt beat. Yeah, if you don't want 35 years, you got to take some licks, buddy. You may have to get hit a few times. 35, that doesn't surprise me, but it surprises me.
Several times he said, there's already been some life sentences handed out.
Yeah.
Hand out another one.
Ugh,
And
that's what the prosecutor said.
So I thought that it would have been longer, or he was certainly wanting longer.
Boy.
But it is, as I said earlier, a sentence that's going to, echo. for
Sure. Okay,
decades.
let's talk appeal.
And indeed it will.
Let's talk appeal. I'm going to pause this here.
Yes, I agree.
Appeal wise, it is extremely hard to win an appeal in the state of Texas. It goes all the way up to the Texas State Supreme Court. The Texas State Supreme Court is primarily Republican. They are elected officials. Every person on our Supreme Court is elected, none of which are appointed. The appeals grounds, people have talked about appealing based on striking the 3 Black teachers. Now, I want to clarify, I did a video on jury strikes, jury selection, how that works. These teachers, it appears they were not struck for cause, that preemptive strikes were used. Preemptives are the strikes you get that you can use any reason whatsoever. Now, because it's any reason whatsoever, the burden then shifted to the government to explain, since they were the last Black ladies left, and it was 3 of them, to give a race neutral reason why they were struck. So the race neutral reason is that they said these were teachers, and they felt that effectively the teachers were going to be too close to it. When the state strikes, the true reason is they felt these teachers would sympathize too much with the defendant. Here's the thing. Ordinarily with strikes, that's how you use them. You use them to get rid of jurors that you believe are going to sympathize too much with the other side. That part is fine. You just can't do it based on race. So it comes from the law. I worked on the case in law school. The law where it was because in Dallas County, they used to have a prosecutor's manual that they gave to all incoming assistant prosecutors. That said, when you're doing jury selection, do not select any blacks, don't select any Chicanos. That was the word, I read it. And it said, don't select any Catholics or Jews on the jury because they sympathize too much with defendants. That was a policy of the prosecutor's office of Dallas County in the 1980s. It went on to the Supreme Court, and the Supreme Court said that is unlawful. So that's what we're talking about when we say, striking people from the jury. You can't do it in that way. Here, though, one of the interesting facts is they struck those 3 teachers, right? They said it was because they are teachers. They can do it based on teachers. They can't do it based on race, but there was a teacher that made it onto the jury. I delved into that a bit further. I feel they still have an argument that based on how the Texas Supreme Court works, they are probably going to, the state will win. It will not be overturned based on that. Why? Because the argument is that they kept that one teacher that is not a black teacher, because although she has a teaching degree, she's no longer working as a teacher. She's an esthetician. That's interesting. That can fly if the argument is that those teachers might be too close to the facts or the procedures of that particular school district or the school. But if it's that teachers generally will sympathize too much with the defendant, that's a problem, because even though she's doing makeup now, she still at one point had the mentality of a teacher, arguably had the mentality of a teacher because she was teaching. You see if I follow that. So far, it seems as though that would be the strongest appeals grounds that they could bring of the things that I've witnessed in this case, but I still don't think that would be enough. You've asked. Oh, yeah, I don't know exactly what it is, but they said she's some form of an esthetician today. Yes, a teacher did make it to the jury. Okay. Did I agree that Karmelo should not have been charged? I see why they charged it. So they charged with whatever the highest they think they can prove. I think manslaughter would have been more fitting because of the fact that it was one stab. One. If he would have kept going at it, then I could have seen murder, but clearly, they disagreed with me and they didn't see any form of sudden passion. You guys, this was a case where Collin County used it to make an example out of this young man to show, don't come to Collin County with your foolishness, with your violence. This is not the place to do it. And I totally understand a community wanting to make such a thing clear. I don't know that this set of facts is the one that illustrates the danger that Collin County residents have been facing lately. I don't know that that's this. If Karmelo would have waited and actually gotten hit, we wouldn't be here. That's the difference between all those cases. You have to actually be attacked. I agree with you. I don't know your race. I don't care what your race is. 100%. If he had been getting beat, even if it was just by Austin, I agree with you. I think if Karmelo would have gotten hit, another offer would have been on the table had he actually took a few punches. Because Texas, someone had asked, why couldn't Karmelo stand his ground? The issue is against what? It's not standing your ground. Yes, Austin assaulted him. And I think that has been minimized too much in the trial. Austin did assault him. However, there were not facts that supported raising the level from the shove to using a weapon. And I think that's where the difficulty lies. There we go. That's where a lot of the difficulty lies. You got to get from the shove to a weapon, because these are mamas and daddies on the jury. And remember, that jury had 5 white males. And what happens when you have men like that on the jury is that men are tough. Men are like, man, take a punch, man. I get it. They better keep the same energy with any person. Yes. And many I'm saying his lawyer put up a lousy defense. I just hate that there were not cameras allowed in the courtroom, because I think the community would feel better about the verdict if they felt there was more transparency about the facts. If the only reason they would appeal, it would be to get a GoFundMe. Okay, well, all right, let's see. Thank you again for the super chat, Ayana. It says, in my example, when I said what I would have done was not focusing on self-defense, how would I have negotiated even though he did it and it's not self-defense? I would have said, hey, some form of manslaughter. Let's agree to a range we're okay with. That this was a kid that panicked. He panicked. He overreacted. He should have kept his hands to himself. You got to go in there with accountability if you want to offer on the table. You got to get 2 things. You got to get accountability, and because you got to remember, you don't just got to convince the DA, you got to convince the family on the other side. Now, there's a chance the family on the other side is like, nope, we want life, a life for a life, and there's nothing you can do there. But I would have argued for some form of manslaughter. That's why when in my previous video where I talked about the sentencing range, I said, if it were possible, I'd go in there and say, you know what? He's a teenager and he thought this was self-defense. But that wasn't reasonable. That wasn't reasonable on these. However, this is not cause to ruin 2 lives for an immature mistake. He stabbed the young man 1 time and ran off. And his own statements state that he didn't even comprehend that his one mistake would have taken this young man's life. You really got to get in there like that. Yeah, Blaze said, I wish he would have gotten there and simply fought him. Yes, take some licks. Take some licks. Karmelo wasn't jumped, y'all. We can't say that. If the facts were there, I would rock with you, but the facts weren't. He wasn't jumped. One person assaulted him, and the other kids were laughing at him and standing by as the other person assaulted him. So we can't say that's jumping. Thank you for clarifying. The money was frozen. Yep, y'all are comparing it to Amber Geiger. Amber Geiger was a police officer that unalived Botham Jean. She got 10 years in Dallas County. And this Dave is saying he thinks 10 to 15 would have been fair. I thought 10 would be fair here too. Here's what's interesting though. I'm glad that you cited that, because with the Amber Geiger case, so Amber got 10 and people were thinking she could be out after 5. Amber is still up in there from my understanding. If someone could Google that in the chat and just confirm. I know for a fact at the 5-year mark, because baby, I had it on my calendar. I had it on my calendar. I was in that courthouse for the verdict. I was sitting in there crying when that brother got up there and hugged that girl and said he forgave her. It was a big man. And I was like, is she going to get out and fight? And she did not. So that goes to show the parole boy, makes that ultimate decision. And I think that the more the impact on the victim. So like if you take a life, that parole board is a lot less likely to give you out, to let you be out on parole earlier. Hold on. It says Symone requests the video. Was the man telling the truth? I want to see the video. Which one? Are you talking about the video of the Oh, let's see. Okay, Carmelo was getting beaten. He got jumped by 4 boys. The original Billy Ilias. Okay. But the YouTube judge would not allow their. Oh, we need to see it. We need to see it. Let's find out. That now when we're talking about appeals, this if there is footage that more clearly shows or even alludes that he's getting jumped or beaten by some boys, that's the stuff that'll get you an appeal now. So the largest grounds for appeal are evidence that would mitigate, evidence that would exonerate a defendant or support a self-defense defense. You are more likely to get something overturned if it is ruled that a judge prevented you from including something like that. Yeah, I'm sorry about this raggedy internet. 35 years with a minimum of half is absolutely fair for unalived another kid with a deadly weapon on school property. Yeah. All right, let me go back to this. Where are we? Hold on. All right, then we've got, okay, at Fort Dread. Do I think there was some motion in limine that handcuffs some of the defense, even that they could cross it? Yes. Yeah. Yeah, well, so, I don't know, did you see it? Oh, I did not post it to my YouTube channel. But one of the things I'm very curious about is, so there would be a motion in limine to limit it's something called bad acts, discussion of bad acts, but it could also be limiting some of the naughty things. I'm going to say it naughty because these are teenagers that Austin may have done in the past. Now, everyone was shocked that they didn't call Austin's twin Hunter or the daddy. Some people are like, well, the daddy wasn't there. You always call the parent. The parent was at the hospital when they were pumping that baby trying to save them. You always call parents or siblings because they set the tone for the character of the person, the type of the person, what they're missing, all of that. It was strange to me. You didn't call the twin who was right there. Baby, that should be your first witness. Well, it is alleged the reason they did not call them is because the brothers have a history of being known as bullies. These were rumors from before. Bullies within the community, bullies within school. Now, if you put Hunter on the stand, you get to cross-examine him about being punished at school, being reprimanded, both what he knows about him and his brother. So by putting him or the father on the stand, because both of them would have first-hand knowledge, was suspended from school for fighting or violence or anything like that, that would open the door to that. So by not calling either of the parents, it prevented the ability to put in certain information. And motion in limines are a second way that could have been limited. But also motion in limines specifically say things like, you may not mention that Austin previously gotten in a fight a month earlier with a teammate, a classmate, a whatever. Okay. And it says, it should have never escalated to the point. Agreed. It should have never escalated to that point. Someone is, wait, I want to see. And then it says, hold on. Why didn't the defense bring in Karmelo Anthony's medical disability? They didn't even include how the twins knew Brazilian jiu-jitsu. Okay, this is a perfect example of a fact that if they had put Hunter on the stand, they would have been able to elicit it. If they put the brother, the surviving twin brother on the stand, they would have gotten this information out. You can only get that type of information out from people who have firsthand knowledge of it. So like you could have, so if no one else knew that they did jujitsu or seen it or had any firsthand knowledge of it, you can't have anyone testify to that. Secondly, I don't know anything about Karmelo's medical disability. Tell us about it in the chat. But is it a disability that would have made him more fearful? Now, I will say there was some commentary like, why didn't they call Karmelo to the stand? Now, in some states, if you want to plead self-defense, you have to take the stand. In certain states, but you do not in stand your ground states. So Texas is one. He did not, have to take the stand, but it does make it more difficult. However, it's almost malpractice to ask for a teenager to take a stand in a case like this. I don't think that whatever he would have said would have flipped the needle. Again, like I said, I already think self-defense would have been too much. It was too much of a stretch. Perhaps it would have humanized him to get less than 35 years. That's possible. But what it does is it would also open up Carmelo's entire school history, any and other suspensions. He would have had to talk about that. Because I'm not going to assume, just because I don't know about it, what's in Carmelo's school record. We don't know. His lawyer knew the consequences if he would have won this case. Lawyers are part of that. Can I request? Sure. Yes, I will happily use the Open Records Request Act to get that video. Let's watch it together. See, a lot of people didn't watch the trial at all, but this is my point, and we're going to close shortly, but this is my point. I think that's what the judge wanted. He didn't want y'all to watch the trial. That's why he did not agree to let it televised. Here's the thing. In Texas, any judge can agree to allow TVs in. It is a judge by judge decision. That judge did not want that national attention on the case. He just didn't want to be bothered with it. Great question. How come the media wasn't allowed? I actually think that this should be a more standardized. I think there should be legislation to be a more standardized decision. I do not think it should be a judge by judge decision that a judge can just be like, no, not here. I think there should be standards. It should be, is this a case that is garnering national attention? Is this a case that involves public trust? Blah, 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 blah. I'm not saying or something like that, but I don't see any justification. Think of it this way. If a case is so high profile, you have to put a gag order, then you need to put a camera in there. I'm going to say it again. If a case is so high profile that a judge feels the need to put a gag order on the case, then you need to have a camera in the trial. Hello. Duh. So someone is saying they showed the video. So allegedly there is an additional video. There is a 4K level video. And then someone is also providing commentary that says he saw a video that showed Karmelo being jumped. But that we get Starlink so this never happens again. But in conclusion, yes, the cameras should have been allowed because it was so high profile. Someone said very few protesters. Yeah, I'm not sure. Why were other courtrooms shut down while the trial was in session? It was very odd to me that they didn't have an overflow courtroom. They just had the one. And it seemed like he very much wanted to limit it. Why doesn't intent matter? Well, intent does matter. In this jury found that Karmelo intended to take this young man's life, or at a minimum, the wording was either that he intended to take the life or quote, and recklessly or knowingly. Knowingly is if you do it with such reckless disregard for the serious risk of death. So, and I think it was because I've heard people say, and it makes sense because of where he was stabbed. They said, it'd be different if he stabbed him in the arm, in the leg, or the arm. Because you know how like there's a place in the leg, if you stab someone, I think it's like the femur or something, and then it could bleed out, and that's how the person passes. They said, but the heart is that's where you get them. The judge knew Austin's father. Okay, let me conclude on this. All right, so we've clarified there was the photo. Now, the judge and his daddy may have known each other, but there was a photo. Let me see if I can put it on the screen. Let me see. So I want to put it on the screen. Here it is. Got it. There we go. All right. So this is the photo. Secret Service Sam published it that his understanding was that this is the district attorney. This is Austin's dad. The victim's dad is in the black shirt. I believe the DA is either the left or the right. I'm not sure, but Judge Roach is not, in fact, in this. So I would just like to take a few minutes before we end to just debunk a few myths. Yeah. So no, Judge Roach is not in there. Judge Roach, let me show you what Judge Roach. Look, you know what? No, I'm not going to show you. You can just Google Judge Roach, Collin County. I don't freaking trust my internet enough. I'm scared that if I just add one more window, it's going to go berserk. Yes, I do need to fix my internet. I appreciate you guys tolerating me. Somebody said, "Where is Ben Crump?" I'm going to go back to reading super chats, make sure I didn't miss any. Nope. Okay, I got it. I think I got them all. But going back to some of the myths. So one of the myths is this was his dad. No, we don't have any evidence of that. That wasn't his dad. Another myth that we've seen is that he was getting jumped. None of the students that testified to that said that he was getting jumped. We don't have any defense parties that even the defense didn't have anyone to call to say that he was getting jumped. That was not the case. There was about a 60-pound difference. The young man was a linebacker. Karmelo was like 140 pounds. There's about a 60-pound difference. But again, like I said before, you got to take a punch. You got to take a few punches before you pull out a weapon. It is really heartbreaking. Yeah, Ben is a civil attorney. You are right. Well, Ben Crump's a civil rights attorney. If there's no money, there's no Crump. My first $1 million case that I had, that I've won on my own, was a Ben Crump case. Either way, I don't believe Carmelo stood a chance. Yeah, I think Carmelo's issue was he didn't take a punch. I am going to teach my kids, my nephews, if you are going to elevate it, you got to take a punch. You got to take a punch. A few of them. So who is in the photo? I don't know. Yeah, you got to take a punch. I don't know who's in the photo. I know that it's the district attorney and Austin Metcalf's father. Austin's father is in the green. Yeah, a weapon is only if your life's in danger. Why didn't one of the great lawyers take the case? Hell no. Okay, let me tell you why. Hold on. They don't have to. Well, and by they don't have to. Why didn't one of the great lawyers take the case? I know exactly what you mean. I know what you mean. Now, in Texas, just to let you guys know, we use a public defender system. Now, yes, there is a public defender department, but that's actually rarely used. In cases like this, in murder one and all of this, what we have is an appointment system where it is voluntary, but private attorneys can volunteer and choose to be appointed to a case, and then the county pays them. So it's not like a public defender like you see on TV where that person has like 10 million cases and they don't sleep, they're stinky, their clothes aren't ironed. That guy, we don't have those anymore. Now it's literally, I used to do it, it's private law firms that get paid by the county to take on cases. And I believe that at least one of his attorney may have been so appointed. It's not sure. Now, Toby Shook, which was on the legal defense team along with Mike Howard. Someone in the chat said that Mike Howard was appointed in that manner. It would not surprise me if Toby Shook was as well, just because Toby used to be a head DA for Dallas County, but I am simply not sure, so I'm not going to lie there. What did he need an expert to prove or refute? Yeah, I agree too. The expert, some have said the expert could have come into play to discuss the psychology behind a child in that environment feeling the need to defend themselves with the knife. I think it's a stretch. Because the other part of an expert is a judge has to feel that that expert is giving more than just common sense testimony, that that expert is coming in to provide knowledge and expertise that is required of an expert, that is more than just what an average person could figure out. Let's be for real. If it was the other way around, it would have been, I don't know if it would have been self-defense the other way around, but I do know if it was the other way around, I don't think he would have gotten 30 years. I think Austin would have gotten 20 or 10. Because they would have said, this was just a fight amongst students, two teenagers that fight that got out of hand. And yes, he can appeal. Yes, he will appeal. That's all I got for you guys there. I'm going to just make sure I didn't miss any other specific questions. I had my notes here. 35 years after 17. He can be out after 17. That's all I got for you guys. Let me know your thoughts in the chat. Thank you so much for the super chats. Yeah. I got it. It's a lot. This is a lot. And let me just say this real quick on my way out. Is that for the people saying this isn't about race, this isn't about race. What was interesting to me is how there are people that I was seeing in the comments all over social media and YouTube who I know for a fact ain't never paid attention to a court case before, except for maybe their own meth head case. Maybe their own case of, I don't know, they mama and they sister fighting each other or get into a fight at the Dollar General, okay, and beat up the cashier and having to go down to the courthouse. Okay, they have never paid attention to a case like this. And they are in those comments and they are trying to correct you and tell you the law and that. So it's real interesting how it has really brought some people to the law who otherwise were just on the other side of it. But also, I'm very interested in why some of these people who literally don't care about anything but their Confederate flag, fixing up their jalopy of a truck in their mama's front yard right next to their broke down trailer, all of a sudden these people really care about the system, about the government. They care about the law. They want to tell you what the law is. Very interesting. That's suspicious. All right, y'all. Y'all have a good one. I'm your legal bestie, Attorney Symone. Hit that like on your way out and the subscribe.
Is that legal? Is that legal? Is that legal?